Well, Tuesday morning after the long weekend, and it's a pleasure to welcome to our studios Nancy Ling from FH&P for our Tuesday morning law talk. Big words, my dear. Ademption and abatement, that sounds like a rock group.
Yeah, it's really just a simple way to say what happens when your intentions aren't actually carried through properly. So if a gift in a will fails, or if there's not enough left for that gift to be made.
So to John, my distant cousin relative by my fourth marriage to the whatever, I leave $10,000. Mm-hmm. But what if that $10,000 doesn't exist?
Right. So there's a couple of different factors here. So a gift adeems if you give a gift of something and then when you die, you no longer own it. So I leave my 67 Mustang to Phil, but when I die, I don't own a Mustang, so you don't get one. That's ademption.
Oh! Is there somebody I can protest that to?
And abatement is, say, I leave $100,000 to each of my 4 children, but when I die, I only have $20,000. So it's not possible to give out $400,000 when I only have 20.
And what you're saying is that as the document was written back 15 years ago, it was possible for me to leave each of those children the $100,000, but because of a stroke and a heart attack and hospital bills and so on, I can't do that anymore.
Exactly.
And I die.
Yeah.
But the will wasn't changed.
Right.
Okay. All right. Now I'm with you. The will didn't get changed to reflect the current situation.
The change of assets. So I'll talk about both of them because there's some different factors in both of them. But for starters, just the concept that when we leave cash gifts, we put a number value on a cash gift we want to leave someone, those generally come off the top. So if I leave, like I said, $100,000 to Sue and then everything else goes to Tom, that $100,000 comes out first. So when I wrote the will, if I had $1 million and I expected Tom to be the big inheritor and I really didn't like Sue, I was just giving her a little bit.
Oh, so the $100,000 was the go away and shut your mouth? Yeah, okay, follow you.
But then if I die broke, I'm actually leaving $100,000 to Sue and perhaps nothing to Tom. So cash gifts come off the top. Residue is what's left. So we don't always know what's going to be left at the end of the day.
And so Tom, who believed that he was the favored child or that he was the one who was likely to inherit, suddenly is looking on because Sue, in fact, didn't get 100. She got 80 because there wasn't enough money. But her 100 became 80, and then there's nothing left for me. Right.
So it's a good idea to think about everybody when they're planning, they think about what they have now. But it's a good exercise to think about what if your assets change? What if your situation changes? Does it make the most sense to leave a dollar value? Or would it make more sense to leave percentages? Because percentages, if the value of your estate changes, the percentages will stay the same, right? You'll make sure that you actually wanted Tom to have 80% and Sue to have 20.
Right.
Then if you say that, that'll still work, even if you only have $20,000 when you die.
So Sue gets $2,000 and Tom gets $18,000.
Exactly.
Okay.
So it's all in how we draft things. So, but the other thing to think of,
and I always do this, and I'm sorry, I apologize to you, but will most lawyers who write wills see that? Because you've just defined for me a scenario that as I'm the person who is creating the will, does the lawyer automatically say, listen, Phil, I see these numbers that you're attaching here. Wouldn't it be better if you just did it on percentage basis? I hate to put it in this context. Are the lawyers smart enough?
It's always a conversation that we have or that you should be having with your lawyer when you do the estate plan. When you talk about if you are giving a specific amount or even if you have got items passing outside of the will, like by putting a designated beneficiary on a bank account. Having the conversation about if you change that or if your situation changes, you need to update this will. Or in the alternative, think about just doing percentages. So that should be a part of the discussion that happens because frequently clients will change things, change the way they hold assets without necessarily telling us. So the plan that's set out in the will won't apply the way it was intended to. So if you ever make a change to your assets, it's a good idea to talk to your lawyer about whether your will still works the way you want it to.
Okay. And I've got some real life examples here because my sister and I are both caring for our mother. my mother's brother, who at one point in time we had three of us all who had to agree on what was going to happen to Mom through her brother and her two children, my sister and I. So it was a very complex three-headed animal that was constantly having to work back and forth if we were going to change anything within the will or the disbursements or so on and so forth. The brother has since passed, and so now my sister and I are the only two left with power of attorney. But we, again, find ourselves facing the reality is that what initially had been written about a will and cash disbursements that had been written about a will when the woman was in her 80s, now with her at 93 and counting, that clearly the scenario needs to change. Mm-hmm. And we're having to write and go to Mom's accountants and lawyers and saying, this isn't real anymore. This makes no sense whatsoever because we need this amount of cash flow to continue to maintain her life as she's in her, as I call it, warmly and affectionately, the warehouse, because that's what we're doing with her. We're warehousing her till she gets that final call home.
That's actually another conversation I frequently have with clients when they've helped out one child at some point during their lifetime. They've given a gift for a down payment or something like that, and they want to help out the other child. So they talk about making these lifetime gifts. And I'm always very cautious about that because they're, again, looking at their situation right now and they can afford to do it right now. But I always want them to be aware that a gift is not money you're ever going to expect to get back. And if they need that money later on in life as their health deteriorates and they need more aid, maybe they should wait and give that gift in their will so that they know they'll have the money when they need it. So,
but the inclination is that I want to do this while my mental faculties are clear and crisp.
Yep.
And the conversation that I can have with the child who's the beneficiary, that we can have a warm and fuzzy, because that is the natural humanity of all of us.
They want to be fair. They want to be able to watch their children enjoy it. But
there you go. That's the point. You want to watch your children enjoy.
I still want to make sure that it works with their budget and people are living much longer these days and that they've got a plan to have some money available for them later. So we draft the wills so that these gifts that we want to leave will hopefully still work. But at the end of the day, if you die broke, you want to make sure that it's still as fair as you want it to be, or it still did as much as you wanted it to be. Assuming there is something left in the estate, it would be split the way you wanted it to be split.
We are in conversation on this Tuesday with Nancy Ling from FH&P and talking about two words that until today I'd never heard of, ademption and abatement, and what happens when gifts in a will fail because the money no longer exists. We'll be back to continue the conversation with Nancy Ling in a moment. Absolutely fascinating and very close to life for me in my particular situation, and I'm sure quite likely to some of you. Nancy Ling in our studios, and we're talking about the whole process of writing wills and making bequeaths and setting out the amount of money that will be given to somebody on my death. But what happens when the death occurs and there's just not enough money left in the will? That's a big challenge for a lot of things, and I really do like this whole concept of write it as percentages as opposed to hard numbers.
Mm-hmm. That's one way to make sure that your actual intention is carried out. One other thing that I wanted to point out, because we were talking a little bit about power of attorneys, is that there is a saving provision in the Wills, Estate, Succession Act. So if you, as executor, as the will maker, as testator or the will maker, had left a specific gift in your will, you wanted a car or whatever to go to a specific person, and then say you lose capacity and your power of attorney takes over and starts managing your assets for you. They then sell that car, which you'd intended to gift to someone. You then, as the person who's supposed to receive the car, gets the value of that gift because it wasn't disposed of by the will maker. The will maker's intention was you to get that gift, so you still get the value of it. But if if the will maker goes and sells that car themselves, then the gift fails. But if a power of attorney or a nominee or agent gets rid of it for them, then you still get the value of the gift.
Okay, and I appreciate that's an interesting context because in our life, meaning my sisters and I right now, There has been fabulous collections of dishes and chinaware and boneware that our family has had for forever. It has been willed to me, but I'm never going to use that. And I said to my sister, I said, you know what? I'm never going to use this massive collection and this setting for 14 people with, you know, any number of plates and dishes and whatever, and coffee pots and urns and teapots. What? I don't live that life or style. So we need to sell it.
Yeah, and that's something you can do.
We need to sell it. And you know what? To my sister, I've said, you know what? Let's just put the value of that back into the will so that we can maintain Mom's life until whenever, because I'm sure not going to need 14 place settings of fine English bone china.
And that's you wearing two hats there. That's you technically the beneficiary, and you're also the power of attorney there.
Yeah.
The tricky thing is sometimes the power of attorney won't know what is the subject of a gift.
Because we're close enough to the individual.
Right. And you presumably know what's in the will. Sometimes the person who made a will doesn't actually tell people what's in it, and you won't find out until after they're gone. So while technically a power of attorney is not supposed to dispose of something that's a specific gift in the will, it does happen because sometimes they don't know. Or,
so bigger question, should your power of attorney know what's in that will?
It's a good idea, but it's unique to each scenario. So sometimes people have very specific reasons why they don't want the contents of their will to be disclosed until they're gone.
Right.
But if there's
hurt feelings, right, or anger or.
Right. But if there isn't any reason why you would want to keep that secret, it is a good idea to give your power of attorney a copy of the will so that they know what your wishes are. They're not going to accidentally frustrate a gift.
Right. Or dispose of an asset that the individual concerned would have been very disappointed to discover had been sold.
Exactly.
Like the collector car.
Right.
The collector car that should have gone to the individual.
Right.
All right.
I've got a couple of other examples here.
Please go. I find this fascinating. It's interesting. Sometimes these conversations have no relevance whatsoever, and then sometimes you are so spot on the money. And I'm thinking that in today's conversation, there's a number of individuals who will be nodding at the other end of the radio and saying, okay, I get that.
Well, the other way we see these gifts fail is quite often with bank accounts. For whatever reason, a lot of people will specifically describe a bank account in their will. They'll leave the funds or the stocks and bonds in this investment account to a certain person. But during their lifetime, they do something that changes the nature of that account. They either move the money. If it's a term deposit, it matures. They take the money out and they buy something with it. So they've changed the nature of that gift so that technically it no longer meets the description in the will and no longer exists. So that happens quite frequently with bank accounts. There was one case where a man had left the residue of his estate to his second wife, but he had left an account to his children, and he described it by the institution, the account number, etc. And then as he got older, he needed to simplify his finances. He was out in Nanaimo, so he decided to amalgamate all of his funds to the bank, the branch closer to Nanaimo. And it was actually a different institution as well. But what complicated that was that he had mixed other funds into this one account, so it wasn't just the original funds. And the Court of Appeal actually found that it no longer substantially matched the description in the will. So that account was now part of the residue and it went to the new wife, which obviously wasn't the guy's intention. He wanted that $100,000 or so to go to his kids. But because the account no longer existed, it went to the new wife. So
again, he should have remembered that and updated the will.
Mm-hmm. If you're going to
forgot about it.
Yeah, if you're going to describe a gift specifically by an account and you no longer have that account, it's a good idea to update your will.
If somebody's suffering from dementia, though, so the will was written when I don't have dementia,
mm-hmm.
and maybe I don't have full-blown dementia when my life comes to a close, but things were somewhat out of step and I was a little disjointed and so on and so forth. Does someone who was going to receive a gift or expected to receive a gift have the ability then to go to court and in the instance that you just described, where an account was changed and the amount of money in an account was changed and so on, and I end up on the backside of a will that really has nothing left for me. Do I go to court and challenge that?
You can. We've seen instances where
based on mental infirmity, or
right, where there was a designated beneficiary on an account, and it was changed at the last minute when it was obvious to certain people that the deceased had no capacity to change the beneficiary at that time. So then you challenge that transaction on the basis that he didn't have the mental capacity to do that when he did it, and so it should be reversed. So that is something that you can challenge. Anytime someone enters into a contract when they don't have the legal capacity to do it, you can challenge that contract.
Is that difficult law to prove?
It can be. I guess it depends on what kind of proof you have. In one case, we had examples of doctor's visits and doctor's letters confirming that this guy did not have capacity. We had correspondence with the bank expressing their concern about how he was managing his money. And there was actually...
So that clearly sets the case and sets the framework, and a judge who's called upon to make a decision wouldn't have any trouble here whatsoever.
Yeah, I mean, you've got to look at the facts at each scenario. Quite often in these kind of scenarios, it's especially if the person banked at a specific institution and had sort of regular finances and they were predictable. Sometimes it'll be the bank that raises the first flag. If they start to see odd withdrawals or more than the person usually withdrew, or, regular cash withdrawals when the person doesn't deal in cash. So the bank will sometimes raise those flags. And then accounts get frozen, power of attorneys get called, things like that.
Difficult.
So there's a lot of factors that come into play. One of the other examples I had was with a house, and this also deals with parents giving stuff to their kids during their lifetime. So this was an example of a parent that had promised the house, the family house, to her daughter, and she also had a rental property as well. But during her lifetime, for whatever reason, she actually transferred the house to her son. So she promised her daughter that the daughter would get the rental property in the will. And she did that. She drafted a will specifically giving the rental property to the daughter. But at the time that she died, she had enough debts and not enough cash that the house needed to be sold in order to pay off the debts. And the responsibility of the executor is to pay all of the debts before anybody gets their gifts under the will. So technically speaking, that property should have been sold to pay out the debts. What the executor did was he asked for instructions because the daughter had offered to pay off the amount of the debts required to free up the house so it could be transferred to her. She didn't want that house to be sold. So the court gave directions that, yes, the daughter could essentially buy out that indebted portion of the property in order that it not be sold.
But the son did not, and the son didn't get the house that he thought initially was going to be bequeathed to him.
Well, he did. It was transferred to him during his lifetime. And the daughter was getting hers in the will.
In the will. Okay. So
the son did walk away with the house, and the daughter walked away with the rental property, but it wasn't essentially gifted outright to her because she had to pay off a certain amount of the estate's debt before she could get the house.
Okay. I see. Okay. So, she became the beneficiary to the brother. Am I interpreting this wrong? I'm hearing of a son and a daughter. Mm-hmm. And the son was going to be given the main house, the family house.
He was. She transferred it to him while she was still alive.
Right.
So while she was still alive, he became the owner of the house. So
yes.
When mom died, she no longer owned that family house.
But she had huge debts.
But yeah, she had debt and she still owned the rental property.
Okay, now I'm following you.
But there wasn't enough cash in bank accounts, et cetera, to pay off the debts. So normally you have to start liquidating estate assets to pay off the debts, right? Because if there's no cash there.
And so the rental property was going to be liquidated.
Yes, it was going to be sold. And the daughter didn't want it to be sold. She actually wanted that property.
Right.
And so the option there was for her to pay into the estate the amount to free up the property.
Okay. And the son, in the meantime, got his property free and clear.
Right. And
there was no attachment to it.
And in this will, I believe that it was she got the house and then the residue, whatever was left over, was split equally between son and daughter. But of course, there was no residue because there wasn't even enough to make a full gift of that rental property. So he didn't get anything out of the will other than what he'd already gotten during his lifetime.
Right. Okay.
During her lifetime, yeah.
Right. Fascinating. Is all of this, any of this, found or to be found on an FH&P website?
I'm not sure. You might find some of our blog articles deal with this, but generally this is something that we have a discussion about with our clients when they come in for the wills meeting. We do a full meeting, we've got a checklist that we go through with the client. We have all of these discussions. And depending on the client's particular circumstances, this discussion and others will come up. It's all about recognizing what each client's needs are.
All right.
So it is a discussion.
And a fascinating one as well. Nancy Ling in our studios this morning with FH&P. If you'd like to connect with her directly, you can find her at the other end of her direct line at 448-0527.
Yes.
448-0527. Or the other thing you might want to do is go to the website and just go to the drop-down menu where it says lawyers, and you can find her there. Really appreciate this one. Thank you very much for coming in.
My pleasure.